Yo, what up, what up, what up, and welcome back to Pnoid News. Man, listen, all right, I'm supposed to be at work right now, but I'll be honest with you. I just saw this story as I was walking out the door. You know what I'm saying? I was getting up to leave, and I was like, yo, we got to cover this. It is what it is. Like, there's no choice. We had to cover this. All right, so this is from Reuters. U.S. Supreme Court rules for Nestle and Cargill over over slavery lawsuit. The U.S. Supreme Court on Thursday threw out a lawsuit accusing Cargill Inc. and Nestle NESN or whatever subsidiary of knowingly helping perpetuate slavery at Ivory Coast cocoa farms, but sidesteps a broader ruling on the permissibility of suits accusing American companies of human rights violations abroad. The 8-1 ruling, authored by Justice Clarence Thomas, reversed a lower court decision that allowed the lawsuit. Brought on behalf of a former child slaves from Mali who worked at the farms, filed against the companies in 2005 to proceed. Yo, look, I'll be honest with you. This is important, all right? And we all know why this is important. Due to the amount of slaves used at Apple facilities and Foxconn facilities and places all over the world, that would immediately shut down these assholes' ability to produce goods for nothing and fuck the average middle-class worker in the Western world. This is a giant, important story that should be getting every ounce of news coverage that the election got. But unfortunately, America is lux populi suprema lex. What's good for the luxury of the people is the supreme law. That is how our government is run, and that's how the government sees it. It's a very simple premise to understand. What produces the most goods is what really matters to this country. It doesn't matter about the health of the people. It doesn't matter about the health of the world as a whole. All that matters is that these companies continue to make money. Nearly all the conduct that they say aided and abetted forced labor, providing training, fertilizer, tools, and cash to overseas farms occurred in the Ivory Coast, Thomas wrote. The business community has long sought to limit corporate liability under this law. Nestle never engaged in the egregious child labor alleged in this suit, and we remained unwavering in our dedication to combating child labor in the cocoa industry, a Nestle spokesperson said. They know that's bullshit. A Cargill spokesperson said the company is continuing to keeping child labor out of the cocoa supply chain. We do not tolerate the use of child labor in our operations or supply chains, and we are working every day to prevent it, the spokesperson said. The justices stopped short of definitively deciding the question whether the U.S. companies can ever be sued under the 1789 law. Cargill and Nestle had asked the court to bar such lawsuits in all circumstances. See, in 1789, people knew better than we do today. The lawsuits targeted the U.S. subsidiary of Swiss-based Nestle, the world's biggest food producer and commodities trader Cargill, one of the large privately held U.S. companies. The plaintiffs accused the companies of aiding and abetting the human rights violations through their active involvement in purchasing Ivory Coast cocoa and turned a blind eye to the use of slave labor on the farms, despite being aware of the practice in order to keep the cocoa prices low. All that matters is fucking profit. It's that simple. Anyway, yo, look, I think y'all got the basic premise of all this. I know this is like a long ass, well, there's a little bit more left in this article, but there's not a whole lot, right? Yo, look, Tom Peace and Pnoid News. Y'all know the deal. Like, share, and subscribe. Peace.